with that incredibly broad legal theory of what transmission is, there's really not much left for a jury to decide as far as whether you were guilty of unlicensed transmission or not, because basically everyone in crypto, everyone in DeFi is effectively doing money transmission, and most of them don't have licenses because the regulator told them they didn't need to get one.
Welcome, everybody, to Bitcoin Politics. I'm Frank Corva, the political correspondent for Bitcoin Magazine, and I'm joined today by none other than the executive director for Coin Center, Peter von Valkenburg, an absolute legend in the space. Thank you for joining us, Peter. And also, just a quick disclaimer to the audience. I'm recording from across the street from the courthouse where the verdict in the Tornado Cash trial was just read aloud. So there's a little bit of background noise. I'm at a cafe. Just asking you to bear with us. I will mute myself as Peter's talking to keep that background noise to a minimum. But again, just a little sort of patience. Bear with us here. We're trying to kind of get you the most timely information and analysis possible. And again, with Peter here. So Peter, to you.
There's just not that many places in Lower Manhattan where a man can record a podcast, even at an important moment. So I'm glad you're there covering this, Frank.
Appreciate that. Yeah, there are not many places. It's kind of surprising, and Starbucks is even louder, so I couldn't go there either. So anyway, Peter, thank you for doing this. I think you're the perfect person for us to speak to about what just happened. So let's just dive in from where we're at. Within the last hour, we just had the verdict read aloud in the Tornado Cash case. Roman Storm found guilty of count 2, conspiracy to operate an unlicensed money transmission business. Jury not unanimous on counts 1 and 3. Count 1 being the conspiracy to launder funds, and then count 3 being the conspiracy to evade sanctions. There's some more detailed language there that I'm skipping over. Your thoughts on where you're at? What were you expecting? What is your reaction to what just happened?
Yeah, so just a little bit of extra legal color on what all that means. The unlicensed money transmission charge is the one guilty charge from the jury. The two other charges, they failed to reach a verdict, which means that he's not going to be guilty of those charges unless the government comes and retries or reprosecutes those two charges, which I think we'll find out in the next hours or days whether they're going to decide to reprosecute those charges. But the Roman himself, I think, actually said it best. I just saw a tweet reaction somebody caught from him where he said, not feeling too bad. The 18 USC 1960 charge, the unlicensed money charge, was bullshit from the beginning. And so we can fight this one and we should appeal. And I agree with that colorful but accurate summary 100%. The unlicensed money transmission charge is that charge that you've probably seen Coin Center, my organization, the DEF, the Blockchain Association, a bunch of orgs in DC yelling and complaining about, because it just doesn't make any sense legally as to how we would sanely regulate crypto in this space. That charge says that you are transmitting funds without a license, and you knowingly transmit criminal funds. Now, the question is, who needs a license? That's really a legal question, not a factual question for a jury. And the legal question, in Coin Center's opinion, and I think anybody who's reasonable on the law here, is that question got answered in 2019 when FinCEN, the federal regulator for money transmission registration and anti-money laundering controls, said you're only a money transmitter in crypto if you have total independent control over customer funds. That was the 2019 FinCEN guidance. I think they were incredibly clear. We praised the guidance when it came out. Lawyers wrote opinions for their clients relying on that guidance, saying, yeah, you probably don't need to worry about unlicensed money transmission because FinCEN just said that you only are transmitting money if you hold funds. And so a developer like Roman Storm, who builds a protocol with smart contracts that are immutable, with a front end that's non-custodial, in theory, should not be worried about unlicensed money transmission prosecutions. Yet, lo and behold, not many years after that guidance, a couple years ago, he gets prosecuted by the DOJ for unlicensed money transmission. So to me, that charge never should have been brought. And now you might be asking, okay, so why is he guilty of that charge and not the other charges, the money laundering charge and the sanctions evasion charge? And I think the fact of the matter is it's mostly a legal regulatory question whether you are going to be guilty or not of that charge. The court will basically say, this is what we think the law and the regulations say money transmission is, And then they'll throw it to the jury to say, if they're doing what that thing is that we call money transmission, you, the jury, need to decide whether they were licensed and whether they knowingly transmitted criminal funds. And so the jury is not really left with much discretion. All of the important questions as to what money transmission is were decided by the judge during the motion to dismiss phase in this prosecution last winter. And the judge, in our opinion, got it completely wrong. Judge Fela basically ruled that for this court's purpose, money transmission is broader than what FinCEN, the regulator that you'd register with, says it is, and effectively extends to basically anyone who facilitates the movement of tokens on chain. So that and with that incredibly broad legal theory of what transmission is, there's really not much left for a jury to decide as far as whether you were guilty of unlicensed transmission or not, because basically everyone in crypto, everyone in DeFi is effectively doing money transmission, and most of them don't have licenses because the regulator told them they didn't need to get one. So, in short, I think that charge was inappropriate, and it didn't leave a lot to the jury, even if the jury was sympathetic. And at the end of the day, that was a bad combination, and that's, I think, why we got the guilty verdict there.
Appreciate that breakdown. What's next, I guess, is the question on everybody's mind. How quickly does this move to the appellate court? What are the odds at the appellate level? Yeah, I think most people are. I mean, you just mentioned Roman himself talking about appealing this. I've spoken with other lawyers as well who feel that they have a pretty good shot at that level. Your thoughts? What kind of case do they make? And also, if you wouldn't mind maybe breaking down for the audience, how are things different at the appellate level? It's a much different setup than the way it has been at this in this other district at the federal level. If you could break that down, I'd greatly appreciate it.
Yeah, so appellate courts, just generally speaking, are focused on the law, not the facts, and that's not a problem for us here. In fact, that's a good thing here because what we think went wrong with this trial was the law, not the facts. It was this incredibly broad definition of money transmission that's actually exactly counter to what the relevant regulators said the definition of money transmission was. And so you'll get a deep dive into the law. You'll get um, a judges who are, their expertise is in statutory interpretation, their expertise is in questioning legal theories either from the prosecution or the defense, and they'll give Storm's lawyers an opportunity to really make their case that what went wrong here is this rather absurd ignoring of the FinCEN guidance, instead siding with the prosecution. And so, I'm optimistic for that appeal. Coin Center will definitely file an amicus explaining, the long legal history in this space, because we've been working in this space since way before 2019, about how FinCEN carefully weighed the options, got it right in their guidance as to what money transmission is, how people relied on that guidance in this space. And ultimately, that reliance actually really matters as well, because I think one thing that they can appeal on is also a due process issue. It's this situation where the regulator told you were safe and didn't need to get a license, but then you got charged with unlicensed conduct. Who were you supposed to license with to avoid that prosecution? The due process clause of our Constitution says that you have a right to be fully informed of what the law means and what it is, as far as where you have potential criminal liability. And if the law was not clearly explained to you, let alone explained in a contradictory way, you can't be charged with the subsequent violation of that law. So I think the due process claim is important. I think there are First Amendment claims that they can bring back. That was something else that came up in the motion to dismiss. Judge Fela kind of dismissed out of hand the idea that the actions of Roman in publishing the software to the Ethereum blockchain and maintaining the website were First Amendment protected activities, because she suggested that, at least in the Second Circuit, which is the court of appeals that the district court sits under, there's a values based test for whether software gets First Amendment protections or not, whether the software sort of enshrines the values of the First Amendment, or whether it's actually criminal software or bad software. To me, this is actually not good law if you dig into the rest of the Second Circuit opinions on the First Amendment, and also just antithetical to our very notion of the First Amendment. The point of the First Amendment is that people in government, judges, politicians, lawyers, should not be deciding what types of software are good and bad. If what it is software and all you've done is publish it, or publish it to a website and maintain it, then you can't be, on the hook for things like prior restraint. The government can't say, no publishing the software until you get a license from us. That's prior restraint. The Supreme Court roundly rejects prior restraint. So I think we have got some really good arguments for affirmative defenses like due process and First Amendment. And then just going back to that statutory authority argument, like, really, does the Bank Secrecy Act give Treasury the power to license people who are not actually holding customer funds as money transmitters? And are you therefore liable for unlicensed conduct? These are really important questions, and questions that Judge Fela, I think, all due respect, I think she's actually written some very smart opinions in the past, like surrounding Uniswap and some other things. But I think she just got this wrong and didn't delve into the legal nuances sufficiently. So I'm optimistic there.
So there was, I don't know how much this relates, but there was a Brady request made in the Samurai case where they got
Yeah,
information where they had spoken with two different FinCEN officials,
yeah.
fairly high-ranking officials within FinCEN, who said, "Look, we don't see any wrongdoing here in terms of money transmission. Will the Tornado Cash team be able to use that in the appellate court at the appellate court level?"
Yeah. So the Brady law is this law that says that the prosecution needs to disclose certain relevant facts to the prosecution to the defense so they can adequately mount their defense. I'm not an expert in Brady law, and I'm not sure whether this is a clear Brady violation. But that conversation, the fact that that conversation had happened between prosecutors at the Southern District of New York and FinCEN, the regulator, at least can enter, I think, into the legal discussion of, all right, we have clear statements from the regulator as to what money transmission is. We have, the prosecutors aware of those clear statements. And so from a due process perspective, it just looks like really bad faith to bring a prosecution against a potential defendant who, in theory, had the law clearly explained to them. And we know they relied on that clear explanation to assume that they weren't transgressing the law, and yet they still get prosecuted anyway. So I think it's tangentially relevant to the due process claim. It just obviously makes the prosecution look bad faith, and I think that that will all come into these questions of, like, how broad is money transmission legally, and can we really, in good conscience and under our U.S. Constitution, hold someone liable for a violation of those statutes when they were explained to them in the contradictory way?
Understood. So speaking of money transmission charges, we had the Samurai developers take a plea deal in which they pled guilty to their second count as well, which was the money, or one of the two
Yep.
counts, not the money laundering, but the money transmission charge. Your thoughts on that? This has been discussed, but I think it'll be good for people to hear from you. Does their taking a plea deal set any sort of precedent? I think it's common, well, not common knowledge, but it's fairly well known that it's not the same as a decision being made after a trial, being made in court, as
Yeah.
they're taking a plea deal. What are the repercussions of that? And in your opinion, why do you think they ended up taking the plea deal?
So, I would never criticize a criminal defendant for taking a plea deal. Our justice system, frankly, especially in the Southern District of New York, is heavily weighted towards prosecutors. And, the whole innocent till proven guilty paradigm that we supposedly rely on in this country could use some refreshing. And so if you're facing potential jail time, large potential fines, and the plea seems good, I get it. You take it. Now, am I happy that we ended up with a guilty plea in Samurai? No. I wanted to see it litigated. I'm a lawyer and I'm an advocate in this space who wants clear law. And so the plea, no, not precedential. That doesn't mean that, like, it's now clear law in the Southern District of New York that if you run a coin join server for, confidential Bitcoin transactions, you're an unlicensed money transmitter. That's not the law. The problem is we don't know what the law is. You go back to that FinCEN guidance, and I would say the FinCEN guidance is clear. Operating a service does not give you, quote unquote, total independent control over customer funds. Gives you very, very limited secondary control over messages that customers send, but no control over the funds. So to me, that's not money transmission under FinCEN. It's not money transmission under a reasonable reading of the relevant parts of the Bank Secrecy Act or the implementing regulations from Treasury. And yet they were prosecuted in the Southern District of New York. And yeah, they took a plea deal, I think, because they were looking down the barrel of a pretty serious potential sentence if they fought it and lost. So that's frustrating. Again, I would have loved to see it litigated. You know, I'm sure the defendants would not have enjoyed the process, but we would have had to actually think about, from a legal perspective, from a factual perspective, what does it mean to operate a coin join server? And I think what would have come out in trial is the correct thing, which is that operating a coin join server is kind of like running Craigslist. And yeah, people are going to meet on Craigslist and do things like exchange value. But Craigslist isn't exchanging value. They're just connecting people who are going to exchange value themselves. Just like in the Tornado Cash case, putting software up on the Ethereum blockchain in immutable smart contracts for privacy purposes will help other people move their own money, will help people transmit their own money. But the person who published those smart contracts, Roman Storm, is not doing the transmission and shouldn't be on the wrong end of a prosecution for unlicensed money transmission. It's all just kind of absurd. It's frustrating. I'm a little newer to the Southern District of New York. Lawyers who I respect and have worked with for a long time sometimes refer to it as the sovereign district of New York because they want to be the world's financial policeman on the beat. They think they got jurisdiction over everyone, and that actually goes to the gravity of these cases as well. You might think, oh well, I'm not in New York. Well, neither was Roman Storm. I think he was living in Washington State at the time, and effectively, the prosecutors, they'll set up servers in New York and they'll document how their agents or other New Yorkers are using the tools that you published online, the open source software that you published, in order to claim jurisdiction over you. So effectively, they could go after someone in Kuala Lumpur or in Nashville, Tennessee, or in Los Angeles and say, we're the policeman on the beat and you're doing unlicensed money transmission. Doesn't matter if you're not living in our state. Doesn't matter if the federal regulator for money transmission said you weren't doing money transmission. We're going to arrest you in the middle of the night and prosecute you for a federal felony. It's outrageous.
Yeah, that I learned that a few months back. That idea of even if it happened on a server, and in this, I was sitting in a server within the Southern District's jurisdiction. Then they could claim venue. I was sitting in the Samurai hearing when they pled guilty, and they were just talking. Well, some people in the Southern District had downloaded the Samurai app. They just have
Yeah.
to have that. That's it. Just has to be that simple. It's not like the actors were actually based here and acting here. It's kind of mind blowing, and it gives them the right to sort of lasso in any major sort of financial trial that they want or any sort of case that they want to.
And
I'm
Frank,
curious. Yeah, please.
on that jurisdictional game, it goes both ways. So I'm very, very happy that a brilliant software developer and Coin Center fellow, Michael Llewellyn, who lives in Fort Worth, Texas, upon seeing the Tornado Cash prosecutions, said, "I'm in the process of developing and publishing software for privacy protecting uh, fundraising contracts, crowdfunding contracts, but I'm happy to not publish this. In fact, I don't want to publish this until I get declarative judgment from the DOJ that I'm not going to be the next target for a prosecution." And so he brought that case, a civil lawsuit in Fort Worth, Texas, where I don't know, maybe we have judges who respect the rule of law a bit more, or at least more, questioning of executive overreach and law enforcement overreach. And so I'm very optimistic that his civil suit might actually help us reach clarity there. And Coin Center is supporting his efforts because I think he's doing the right thing, standing up for his rights as a software developer.
Big question in terms of federal oversight here. So a lot of Southern District of New York, I think people think of it more as a regional court system, but it's not. It's a federal. It's part of a federal court
Yeah.
system. And we had an issue. I'm sorry, we had a memo issued by the Deputy Attorney General of the United States in which he specifically said we are no longer going to go after entities like crypto mixers, mixing services, but instead we're going to go after the bad parties, the bad actors who are using these services. Why didn't Todd Blanche? I'll give some background here. I emailed Todd Blanche, that office, almost every other day for a good month, just trying to get him to sit down and talk about whether or not he was providing any guidance or was going to step in at all with both the Samurai and Tornado Cash cases. And he seemed to issue that memo and then sort of disappear, not speak to it at all. What was going on there, in your opinion? Why do you think that memo came out if it didn't seem to have much teeth in this circumstance?
The memo's tough because it certainly strikes the right tone, at least at the title and in the opening paragraphs. The oft repeated phrase from that memo is, "We want to end regulation by prosecution." And you couldn't find a clearer example of regulation by prosecution than the Storm prosecution for unlicensed money transmission. You had a regulator who was saying that this wasn't something subject to their jurisdiction, and then a prosecutor who said that it was. This is regulation by prosecution. Nonetheless, if you actually dig into the deep substance of that memo, It does make this distinction between people who are just providing tools, and then people who are using tools to do bad things like narco trafficking and things like that. And the memo says we're only going to go after the people who are using the tools to do bad things. But if you actually look at the counts of unlicensed money transmission, both of the two counts that were originally brought in the Storm trial, and there were originally two, there was only one by the time we got to trial, are based on doing transmission, right? And so to me, there's a strong argument, I think a pretty unimpeachable argument, that under the FinCEN guidance, neither of those two things is transmission. And we shouldn't be reading more into what transmission is if developers had relied upon that FinCEN guidance for their understanding of what transmission is. But one of the counts says you were doing transmission and you failed to register with FinCEN. The other count that was charged is you were doing transmission and you knowingly transmitted the proceeds of a crime. So if you take transmission out of the equation, just knowingly transmitting the proceeds of crime, it starts to sound just like a money laundering charge, which the jury couldn't even reach a verdict on because I think the facts just aren't there. And so, to me, it's that second charge where they said this is a money transmission, unlicensed money transmission charge, but it's really about knowingly transmitting criminal funds that just confuses juries and ultimately gave the prosecution sort of a way out from that Blanche memo. They would say, "Oh, well, the Blanche memo just said we're not going to go after people who are merely writing tools, and oh, look, one of these two unlicensed money transmission charges is not just about writing tools or not writing tools; it's about knowingly transmitting criminal funds." And so I think the prosecution and the DOJ maybe would argue, and maybe even Todd Blanche, although it'd be very interesting to get his opinion on this, that the memo was not about knowingly transmitting criminal funds. It was about providing tools. Now, irrespective of what Todd Blanche thinks about that or the DOJ, they were still not transmitting any funds. They were just creating tools. So the spirit of the DOJ memo should protect you. But I think there were vagaries in there. They didn't fully resolve things. I think, frankly, the Trump administration could have been much stronger here and said, "Look, like this is just as much nonsense as what the SEC was doing with the good faith actors that were trying to comply with securities laws, but nonetheless got prosecutions against them." And the administration didn't really take a strong hand with the Southern District of New York here. I mean, they took a strong hand with the Southern District of New York in the Eric Adams case, but for some reason, Roman Storm is left to sort of like face a jury, and the jury didn't really have many options given the way the law was interpreted. So, all in all, a pretty bad development, and disappointing.
Agreed 100%. On an emotional level, it was quite hard. I got a chance to speak with Roman Storm a few of these days during the deliberation, speak with his team. Yeah, it's definitely tough to watch this happen. But stepping outside of that for a second and just thinking about what comes next, what might supersede this precedent, we have the Clarity Act with language around money service businesses and the entities creating, I think the language they use in the act is non-controlling technology, which is another word for non-custodial technology, not
Hmm.
being money service businesses, not transmitting funds, not needing a money service license. Let's say Clarity magically gets passed before this goes to the appellate court and that language stays in there. Would that help Storm at all? Would that help his case at all, or not necessarily?
So, just to start, you're 100% right that the Blockchain Regulatory Certainty Act, the BRCA, which got attached to Clarity, is exactly the right policy solution for the scariness and the badness that we're seeing unfold in this trial. The BRCA says there's this class of people called non controlling blockchain developers and service providers. And it's defined as people who don't effectively have total independent control over customer funds. It takes the FinCEN definition, which is a regulatory definition, and puts it into statutory law. Statutory law is really hard for the DOJ to start ignoring. I mean, that kind of be like game over for our, republic of laws, not men. And so if the BRCA attached to Clarity, which is the market structure legislation in Congress, it's already passed the House. If it passes the Senate, if I was a developer, if I was out there publishing non-controlling, non-custodial software, I would feel much better. And we've had, the Blue Matt, Bitcoin developer, very active on X.com, has been advocating for its passage. A lot of folks, who just care about Bitcoin core development or Ethereum core development or wallet developers or smart contract developers support this. And I think it's got a good chance of passing because folks in Congress are waking up to the fact that we had 4 years of a really aggressive regime. And what did it do? It just put good people in jail or scared innovation overseas. So let's stop that. Let's reverse course and fix this problem. And offering clarity on this sort of thing is one of the most important things we can do. Now, does it actually help Roman or the samurai devs who already pled out guilty to money transmission? Unfortunately, no. Laws not retroactive. What I will say is it doesn't hurt their appeal, right? There'd be a way to draft the BRCA that would say currently the law applies to non-custodial developers and we want to change the law. But the BRCA is carefully drafted to say we just want to offer a safe harbor that will be an end run or a way to stop abusive interpretations of existing law. And and I think that that's the important legal point is regulators already don't have the statutory power to do this. Prosecutors are ignoring the regulators and just going completely rogue. And Congress is not changing the law here. We're not asking for special pleading for crypto developers. We're not like, oh, please exclude us from how you'd otherwise regulate financial service providers. No, these people have never been financial service providers. They're communications intermediaries, they're software developers, and we're suddenly throwing them in jail for failure to license, which is basically just a big affront to the First Amendment, the idea that you can publish ideas and technology for human flourishing without first giving government approval. And so we're not asking for special pleading. We're asking for our constitutional rights, and we're asking to not be prosecuted, against our due process. When a regulator says we don't need a license, that should be the end of it. You shouldn't then be prosecuted for unlicensed conduct. So I'm very glad that Representative Emmer and Representative Torres. So it's bipartisan. You got a great, strong Republican and Democrat in the House who were leaders here. They're in House Financial Services. They're on the right committee. They proposed this law. We got Gottheimer and Huizinga, so another Democrat and another Republican on board. We got it into clarity. So, it's in the one of the three or two or three must move packages for crypto legislation, and it passed with an overwhelming majority in the House. It's pretty bipartisan policymaking. We just need to take it to the Senate and pass it. And then a lot of this legal uncertainty that this trial is all about will go away, at least for those who are afraid of prosecutions in the future. Unfortunately, too late for Roman, but I think his appeal is good. It's still strong, and I'm rooting for him. And Coin Center is certainly down to do more amicus briefs if it can help, and also help raise money for his defense to the extent he needs that assistance. But I can't stress hard enough to people listening at home who are worried about their legal liability in this space and want to get good policy in the U.S. Call your senator, not necessarily in the next month, but, keep an eye on coincenter.org and other advocacy orgs will tell you when it's make or break in the Senate to pass the BRCA to fix this problem. That's when we got to apply pressure. We got to get the Senate to get this right. The president's already said he'll sign it. It'll be night and day. It'll be like, I'm not sure what Coin Center will do anymore after that. But we'll have important things to do. But this most important thing about felony criminal liability for good devs like Roman, hopefully that'll be behind us.
It was funny you brought that up. What comes next? That was my kind of other question. So this resolves what you just said, right? So devs can maybe put their head on a pillow at night without stressing too much whether or not they're going to get a knock on metaphorically, if they're going to get a knock on the door.
Or literally, like Roman was arrested
right,
in the middle of the night. Yeah,
right. That's a good right. What else? So I've spoken with a few other people. I've had good conversations with the likes of Roy about some other language in some of the bills, also some of the language that came out in that White House digital assets report. There was some surveillance stuff around the Patriot Act, and this isn't necessarily directly related to what we're talking about here. Actually, there was some language directly related to this around money service businesses where they said, if you're not controlling funds, you're not. That was in that. Not that it's a legal document, but they're at least acknowledging this. What does come next? It does seem like there are still a few things that could be troubling. From what Ovik showed me, there was some language. I don't know if it's in the Senate draft of clarity that talked about, if you do happen to transact with a sanctioned address or something like that, you could be held criminally accountable for something. And that's just everyday people, users making transactions. So what else do we have to pay attention to here? What should we be, again, as you said, we want to be engaged with our senators and our elected officials, calling them to sort of support certain things. What else do we need to keep an eye on at this point?
Well, let's focus on the president's working group report, which you mentioned, the PWG, as I'll probably refer to it throughout my answer. The report is the result of an executive order that came out about 6 months ago that says the Trump administration wants to make America like the crypto capital of the world. We need all of the agency heads, SEC, Treasury, OCC, the banking regulators, et cetera, to review their past actions, rules, guidance, things like that. And in this report, talk about whether this is something we should hold on to or whether it's part of the past administration's like bad approach to crypto, which sent innovation overseas. And there were so I have very mixed feelings about the PWG report. There's some great stuff in there, some very important stuff, like the president, the working group says we should pass the BRCA. And again, for me, that's the number one thing for defending software developers from this kind of unwarranted prosecution. There is also, however, in the PWG report, a couple things on privacy and surveillance that are worrisome. um, they're not announcing any new policies that would be sort of draconian surveillance, but in response to past policies from the past administration, which you'd expect a firm break with, as we've seen at the SEC, like the SEC is completely broken with the Gensler era prosecutions. But in these other areas, like the Patriot Act 311, primary money laundering powers, which I'll describe each of these in a second after laying them out. The 311 powers, the 6050I reporting requirements, which is part of the tax code, and just in general, how we're going to define entities for surveillance regulation under the Bank Secrecy Act, like money transmitters and other categories as well. There's some worrying things. So the 311 powers is this power that FinCEN and Treasury have to designate persons or institutions or whole classes of transactions as quote unquote primary money laundering concerns. If you designate something or someone as a primary money laundering concern, all financial institutions in the whole US regulatory sphere, which is basically the world, need to collect extra information about those persons or places or things and report it without a warrant sua sponte to the government for investigation. In fact, in some cases, they can even be mandated to block any activity with those persons or things, kind of like our sanctions laws. And the FinCEN in the last administration said, we're going to go on and have a rulemaking, as 311 has us do, to declare all mixing transactions as a primary money laundering concern in crypto. And we're going to define mixing incredibly broadly, even to include things like not reusing the same Bitcoin address when you get paid multiple times, which is like basic cyber hygiene. Not because you're hiding money, because you're trying to evade taxes or launder some drug profits, but simply because you don't want the guy who's paying you to know exactly what your Bitcoin balance is, because they could then kidnap you and try and take that from you. Like very basic personal safety matters. So if that's classified as mixing under the last administration's FinCEN rulemaking, and mixing transactions get this heightened scrutiny and reporting requirements from financial institutions, people doing that will effectively be debanked or they'll become subject of investigation for doing absolutely nothing wrong except using this technology in the right way to protect their dignity and privacy. So you'd think the PWG report, Trump wants to make America the crypto capital of the world, would have said, we're killing the FinCEN mixing rulemaking, or at least scaling it back to like knowingly and intentionally mixing, sanctioned funds or something like that. Like just limit it to North Korea, limit it to something. Instead, it's just as broad as it was before. And the PWG report says Treasury should consider next steps. This was an opportunity to say Treasury will drop that rulemaking or do something that honors individual privacy, and it simply wasn't there. So that was disappointing. Doesn't signal that the administration's turning against crypto or doesn't care about privacy. It just signals that they didn't care in this report to actually kill a really bad pro surveillance anti crypto policy that was sort of moving towards maturity. So we'll see if Treasury finalizes that rulemaking, narrows it, which I hope they do, or just kills it, which frankly I think would be the right thing to do, because law enforcement, you talk to most people in law enforcement, they'll say they already have the tools they need to go after and track and surveil on the public blockchain, criminal funds. We don't need to start classifying normal privacy habits as primary money laundering concerns and get extra information from financial intermediaries. So that was one area. The other one is the 6050I reporting requirements. So under the Biden administration, we passed the Infrastructure Investment and Jobs Act, the IIJA, that amended the tax code to say that if you receive $10,000 or more in crypto, you need to collect the name, physical address, and social security number of the person who paid you and report it to the IRS. That is a mass surveillance policy that says that, hey, Frank, if you're taking money from Peter, doesn't matter if you're a bank, just as Frank, you still got to collect Peter's information, surveil his activities, and report it to the government without a warrant. To me, that's an incredibly, anti-liberty, anti-freedom, anti-privacy policy. Congress passed that law, so the Trump administration can't just cancel it. But they could have said in the PWG report that they want Congress to roll that back. I think that would have been the right approach. A bipartisan group of members in Congress in the last Congress actually proposed rolling it back or at least delaying implementation until we learn more about the privacy harms that it could create. But the PWG report didn't say that. In fact, it said we should amend the Bank Secrecy Act to come in line with those tax reporting requirements. So then you'd be getting law enforcement involved in these reports as well as the IRS, and it'd just be even more intimate private information about people's transactions going to the government without a warrant. So I'm not happy about that. I do think there's still an opportunity for Congress to repeal. I hope that President Trump and the working group will reconsider that section of the report and sort of honor people's privacy expectations. But that was a bit disappointing as well. All in all, I still am hugely excited for and happy about the PWG report. Calls for the passage of the BRCA, which will be the best way to stop future prosecutions like the Tornado Cash prosecutions from happening. It does great things vis-a-vis the SEC, the banking regulators, this sort of thing. But those two little things about, and maybe not so little if they end up being the surveillance dragnet, but those two things about the surveillance policies were not great. And if you couple that with the fact that the DOJ didn't really put the brakes on these prosecutions, you start to wonder, like, okay, we're definitely going to be the crypto capital of the world for regulated ETF funds. Are we serious about making America the crypto capital of the world for peer-to-peer transactions and individual liberty? We should be.
Beautifully put. I couldn't agree more. And I guess that's the question in everybody's mind. Are we going to be that? And I'll be honest, when I hear, people got really excited last week. Yeah, it was last week already, when we had Paul Atkins talking about putting securities on the blockchain, updating the
Yeah.
financial. But in the back of my mind, all I'm thinking is like, well, then you'll really need wallets to be, even non-custodial wallets, to be KYC. You're not going to allow people to self-custody securities without their KYC information. And that's maybe I don't think that's the
Well,
case, but
you
yeah,
raise an excellent point. It's a good question. And you actually read the statements from Chair Atkins and Commissioner Peirce more recently on financial privacy, and they're talking about how we should honor the Fourth Amendment. And the Fourth Amendment was written at a time when people could transfer value person to person using coins with no surveillance. And I'm like, yeah, yeah, that is what the founders wanted. That is what America's about. Yes, it carries risks. It carries the sort of like cartoon villain risks of like Hans Gruber in Die Hard with the bearer bonds. But, like, as if the intermediated financial system doesn't carry risks, as if there isn't massive amounts of money laundering done through Credit Suisse on behalf of Russian oligarchs that we only find out about years later. Like, I don't think it's a more dangerous world. If anything, it's a world that prevents the dangers of consolidation of power, corruption, and tyrannical governments. And that's the world I want to live in. And I'm gratified that Commissioner Peirce seems to be pretty jazzed about that world too. And Chair Atkins is moving forward with his Project Crypto. There's so much to celebrate in what the SEC is doing and what the administration is doing. I just do worry about where we'll ultimately fall on this divide between quote unquote national security concerns, because I don't think many of them are legitimate national security concerns, and individual liberty. If anything, individual liberty is the national security concern. Like, we won't be America anymore if we have fully surveilled financial transactions like they do in China and North Korea.
couldn't agree more. I will shout out Hester Pierce as well. I was with her at PubKey when she came there for an intimate sort of conversation with Ross Stevens of NIDIG. Had some genuine things to say. Very, very clearly said that you support crypto mixers. Said something really beautiful. She said, I love tools like Bitcoin. I sometimes wonder what the likes of Harriet Tubman would have done if she had Bitcoin. I was just like, all right, this woman is a boss. So
She gets it. Yeah.
she gets it. Shout out to Hester Pierce. Based on all you've done well over this past half decade in this space, everything you've done at Coin Center, and the progress we've made, are you optimistic that we do get to a world where privacy is maintained, where peer-to-peer transactions are the norm, and where there isn't a crackdown on, where we do stop this sort of prosecution that we're seeing on open source developers?
I am optimistic. I think we're closer than we've been in a long time. I think, there were a lot of dark hours back during the days of the last administration where you saw really overzealous prosecutions. I think there were some investigations that had made a certain amount of headway, and I'm not going to speculate about details. But there are a handful of people who've even come forward and said, "Yeah, I was actually like they searched my house. They had a warrant merely for developing a DeFi protocol." So I think it could have gotten a lot worse, and it didn't. I think also that at the end of the day, peer-to-peer transactions, the ability to hold your own money, these are so inherently American values. And this goes to actually what the SEC was doing in their recent DeFi roundtable. They were like peer-to-peer transactions and the American spirit. It's very real, and it's because we grew up as a nation with this fear of a technocrat overlord telling us what the price of tea should be, and we realized that unless we have the ability to buy and sell tea or throw it into the harbor ourselves, we're always going to be at the whim of that potential tyrant. And so, I sometimes our comms director Niraj will probably throw a book at me for saying this, but I'm like, it is inherently American to say, look, I want you to be able to privately pay for an abortion or privately pay for a gun. Like, that's the only way we're going to agree as America on anything is if the payments are private and available. We can then have big conversations about abortions and guns, but we can't start weaponizing the actual tools of human interaction to bend our policies one direction or the other. That's the end of liberty.
And you're optimistic we don't see the end of liberty within our lifetimes. I say it only because so you just referenced that event that the SEC had, the DeFi and the American Spirit event. And I see the likes of Eric Voorhees in an event like that, and I think to myself like, wow, things are actually changing. And then the cynical side of me is like, oh, that's just sort of some posturing maybe to get people to think things are changing, but they're not. Am I being too cynical when I say stuff like that?
Posturing matters. Like putting Eric Voorhees on a table at the SEC was radical and awesome. Like the guy was he was probably the first crypto guy charged by the SEC because he was selling shares of Satoshi Dice because he was one of the co-founders of that glorious original Bitcoin use case, right? So it means something to have Eric Voorhees. He is a little radical, and we don't have to agree with everything he says when he's on that roundtable. Or I agree with a fair amount of it, but it means something to have him there, to give him the dignity as an innovator, and not treat him as a criminal just because he built tools that actually challenged a lot of people's expectations as to what could be tracked and surveilled, and what transactions could be blocked or seized or stopped. I think that's a great symbol. Yeah, I'm about as optimistic as ever, and I'm about as optimistic about America as any other country. I think, we have the First Amendment, which protects our right to publish software. We have the Fourth Amendment, which should, in theory, require a warrant before government breaks into your private records, whether they're in your house or on your thumb drive. And I think, like a lot of other nations, don't have that. So I really do think there's truth, not just branding in America being and being sort of destined to be the crypto capital of the world. Um, Beyond that, another thing that's really interesting, and I'm seeing a lot of this. We did an event, a private symposium here in DC with some folks from Treasury and Congress and some projects in the space like zero knowledge proof tech type stuff on the future of identity. Digital identity has been a long time coming because current modes of identifying yourself online are just frankly garbage. It's like, to take the 16th photo of your passport that's sitting now in your Google Photos or your Apple Photos drive and hope that it doesn't get leaked, and then they'll hold it and then they'll get hacked and now your passport's on like a data market somewhere. Oh, and tell us your mother's maiden name because clearly the Russian data brokers don't know that. Like that's all absurd. It's garbage. And so there is an opportunity. It's a dangerous opportunity to seize, but there's an opportunity to seize to use, verifiable credentials, like just like you can move your wallet from your driver's license from one wallet to another, you could move a digital driver's license from one wallet to another. Hopefully you control that wallet. No one else should control that wallet. And that goes back to the importance of self-custody and of not regulating software developers for wallets as money transmitters, because that needs to be individual sovereign and not controlled top down. But if you can do that with cash and you can do that with digital credentials, and then you can use zero knowledge proofs to say, all right, the bank wants to bank me, but they don't need to know my home address and my social security number. That's actually a liability. They really only need to know one thing, that I have, not ended up on the OFAC sanctions list and I am a US person. Maybe just those two facts. And if they only collect those two facts from a zero knowledge proof based on a credential I own, that is an improvement. Now, the danger here is if we go down this road of building digital identity, there are going to be folks in Congress, in the agencies, who are going to say, yeah, but we really need a backdoor so that if the government's investigating this account, they can, with a single swipe of a key that they control, learn everything about this person. That's a disaster, actually worse than the very fragmented and bad identity landscape that we have today. But I do think we have this moment to build a uniquely American digital identity landscape that uses strong encryption and decentralized protocols to honor the rights of the individual and not accidentally build a panopticon. But it's a tough one. So that's another, like a whole nother future topic for a podcast or a debate. And Coin Center is going to do more work on it, but it's something that I am cautiously optimistic about.
Appreciate that. I actually had that conversation with Tim Massa, the former chair of the CFTC. I know that he's looking at that as well. I'm open-minded. I'm not a super technical person, but I am paying attention to what that looks
Yeah.
like. And ideally, we don't develop that tech that has that backdoor key. I think that's
To
essential for sure.
to bring it back to Roman Storm, because that's what this podcast was, starting about, and we should give him his due respect because he just, faced this prosecution and a bad verdict right now that he'll hopefully appeal. The Tornado Cash tool had a compliance tool, an open source compliance tool that would prove one thing about your withdrawal from Tornado Cash if you were bringing it to Coinbase, that it was yours, so that Coinbase wouldn't have to worry about like a random North Korean hacker bringing them money from Tornado Cash. I could say, I will selectively unblind using the compliance tool my mix. And now you know that it's just me taking my Coin Center income. Actually, I should have been paid in Bitcoin all these years, but I wasn't. But it's just me taking my Coin Center income, getting privacy on chain, and then going to Coinbase to cash it out. You can process this. That kind of tool, that's brilliant. That's the future. And we should be celebrating developers who are building, multi-party compute, zero knowledge tools for selective disclosure, for compliance as well, because they're building the future, and we need to not put those people in jail. Otherwise, America's future technologically will not be very bright.
Perfect place to leave it, I think. Peter, really was an honor to speak with you at this time. It was really helpful to me. It's great to know that there are people out there like yourself, distilling this information for the rest of us, making it easy for us to understand. And there in the corner of people like Roman Storm, who, as you said, hopefully will appeal and hopefully will continue to do good work as a developer in the future, if that's what he chooses to do. Either way, we really appreciate your time. Is there anything else you want to share? Where can people find you? Any of that stuff? Any resources you want to lead them to?
Everything we do at Coin Center is at coincenter.org, and we are an independent nonprofit. We're not a trade association, so we really do rely on individual donations. If you like the kind of advocacy work we do, please think about donating. Also, we'll be in New York for our annual fundraising dinner in September 25th at the Plaza Hotel. I think we've got a couple of individual seats left. It probably will sell out, but we'd love to see folks there if they want to support us.
Love it. Well, again, Peter, thank you so much for your time. Thank you for the work that you do. Thank you to everybody for listening. And as Peter said, make sure to call your senators, your Congress people, especially when he sort of sounds the alarm and says that there's something pressing where we need you to speak up. I think the story as it's sort of unfolding, it's not just, things are not just going to pan out the way we all want them to pan out, right? We got a lot of work to do, and it has to be each of us doing that work. Obviously, people like Peter doing some more specialized, higher level work, but I think it's important that everybody raises their voices at the very least. So again, Peter, thank you for all you do, and we'll be in touch.
Thanks, Frank.